CRJ 230, this is the week 11 guide. In week 11, I have an article that I ask you to read and watch the video that appears with that article from that website. After that, you're going to look at an Illinois criminal case or find an Illinois criminal case that deals with the exclusionary rule as it relates to identification procedures used by the police. I sort of introduced this last week. All the same parameters, you can't duplicate cases used in that article. But you really need to read that entire article and watch that video. And your case must discuss the exclusionary rule as applied to an issue related to an alleged improper identification. So go do what I've asked you if you haven't done that. Read that article on eyewitness misidentification, watch the video, and then come back and listen to what I have to say. Assuming that you have done that, you know what I'm talking about now with identification procedures, and particularly identification or misidentification from eyewitnesses. The Sixth Amendment of the Constitution states in part, in all criminal prosecutions, the accused shall. When we hear the word shall in the law, it means must. And what the Sixth Amendment says that someone shall be provided with is assistance of counsel for his or her defense. Both pretrial and in-court identifications may be inadmissible if a defendant's 4th, 5th, 6th, or 14th Amendment rights are violated during the investigative identification procedure. Now, there are 3 basic types of identification procedures that we will be concerned with. Show-ups, a one-on-one presentation of a suspect to a victim or witness. These happen all the time, especially in circumstances where someone is pursued by the police immediately after whatever the crime might be, and the police then ask the witness or sometimes the victim to identify the suspect after they've been apprehended. Now, these are usually short in time. These are situations that can be fairly simple and happen all the time. I'll give you an example. Many years ago, I used to take my kids all the time in their little wagon or the stroller and go to the nearby grocery store and walk there and then get whatever we needed. Whatever you need when you have kids is always seems like you need a gallon of milk or something. But I would do that all the time to get them out and to get myself out and to go get some exercise, and because the store was that close and walkable. It was awesome. One day, as I'm entering the store, I noticed an individual who's kind of looks like he was lurking around vehicles. And I waited for a moment, and, that's what he was doing. So I moved my stroller into the store. I was known at the store. I kind of set the stroller near the little office area by where they cash checks and sell stamps and lottery tickets and all that, and asked the lady to pay attention or watch my kids for me for just a second, told her what I was doing. I went and got in a vantage point where I could look out and see. And sure enough, the individual was trying to find vehicles that were open. And he found a vehicle that was open and got in the vehicle and started rummaging through and stuffing things into a backpack. So I asked the lady to call the police. She called the police, and someone else in the parking lot noticed the individual, and the individual got a little spooked. A car came from the nearby alley, picked the individual up, and it took off down the street. I got on the phone and let the dispatcher know what direction the individual had gone, and the police caught the individuals shortly thereafter, within minutes. I had gone on and got whatever I needed at the store, was in the checkout, and one of the officers came in and happened to be one of my former students. And so, officer asked if they caught the individuals. They're about 4 or 5 blocks away. Asked if I'd come and identify the individuals. And so what they did was the lady at the store kept my kids there at the store. I got into the squad car and we drove 3 or 4 blocks, and they pulled the individuals out of the car. I stayed in the squad car. I looked at the individuals. I had no idea what the person who was driving the car looked like, but I was able to identify the individual who was pulling stuff out of other people's cars. That's what it is. Happens all the time. Okay, so that's what we're talking about, a show up. It's a one-on-one presentation of a suspect to a victim or witness. A lineup is a presentation of similar looking persons to a victim or witness. And you see these all the time on television dramas, usually. Law and Order. Law and Order likes to use Special Victims Unit and all those series. They like to use a lineup. And so there's usually so they're behind a two-way mirror. The victim or witness is looking through the two-way mirror at an array of individuals who have some sort of similar looking or similar appearance. And then they ask the victim or witness to pick the person who committed the crime out of the lineup. And then the third one, and probably the one that you will be using most, because lineups take a lot of effort, is a photographic array. And you see these in your television shows and dramas, and you also see them in my favorite show, and I'm not going to name the favorite show. They ought to give me some kind of commercial payment or something. But now, we can do that on our phone, on our iPad, right? And we can have individuals, and you can swipe and have the witness or victim look at photographs. Again, similar to the lineup, similar looking persons, and then see if that victim or witness is able to pick the person who's a suspect or who they believe committed the act or crime out of that photographic array. So that's what we're talking about. Those are the 3 basic types of identification procedures. The United States Supreme Court has held that the right to counsel at trial is a fundamental right. We know this. This right applies to the states through the 14th Amendment Due Process Clause whenever a trial of a defendant may result in incarceration. So, a lot of criminal trials, right? As early as 1932, the United States Supreme Court observed that the period from arraignment to trial was perhaps the most critical period of the proceedings, during which the accused required the guiding hand of counsel. Those are words that came out of Powell versus Alabama. If the guarantee is not to prove an empty right, that's what the court says. So they held that particular moment, those pre-trial moments from arraignment to trial, is critical. And the court applied the critical stage test for the right to counsel. A critical stage begins at the initiation of an adversarial judicial proceeding, whether by way of a formal charge, preliminary hearing, indictment, information, or arraignment. Any pretrial event requiring the presence of counsel can be a critical stage. It's analogous to trial, where the accused may be overpowered by his or her professional adversary and, the state's attorney. The test of a critical stage is whether at the trial itself, no substitute for counsel can be provided to a defendant in the event that a pretrial confrontation is conducted in the absence of counsel, and that comes to us from the United States versus Ash case. Now, in 1967, the United States Supreme Court in the United States versus Wade held that the post-indictment lineup is a critical stage. It's a stage at which the accused is as much entitled to the aid of counsel as at the trial itself. And the Wade decision extended the exclusionary rule to post-indictment pretrial lineups, where a defendant has been denied his or her Sixth Amendment rights to counsel. If a defendant has not been formally charged with a criminal offense, he or she is not entitled to the assistance of counsel at an identification procedure. So if they haven't been formally charged, no right to counsel. When a suspect who has not been indicted or otherwise formally charged is placed in a lineup, counsel need not be present. So know where that line is. Even if no violation of right to counsel exists, an identification may still be excluded, and the core issues relating to misidentification are the due process clauses of the 5th and 14th Amendment. These clauses preserve the right to a fair trial. It is possible for out-of-court identification to be illegal, while the identification made at trial is admissible. On the other hand, if the in-court identification is so influenced by an illegal out-of-court identification as to be the product of it, then the court will find the in-court identification to be inadmissible. Think fruit of the poisonous tree. One bad thing leads to another. None of those bad things are allowed. Excuse me, the old allergies and asthma are kicking up with the spring. Beautiful day, but getting in my lungs. The test is whether or not the in-court identification is sufficiently free of the taint from the out-of-court identification, so it's trustworthy. Again, continuation of the things we've been talking about, right? Moreover, any case involving a legally questionable pretrial identification inevitably involves the question of whether or not the in-court identification should be admitted. That's when it's going to come up. The question is, under the totality of the circumstances, the identification procedure was unnecessarily suggestive, and that's what the court's going to look at. So under the total circumstances, under all the circumstances available to be presented to the court's going to ask, or the decision, the issue that the court's going to decide, is whether that identification procedure, whatever procedure was used, was unnecessarily suggestive. It's a good time to think about the fact that most everything you're going to do is going to be recorded, likely, for most of you and your careers if you go into the justice side of things. Know the procedures, know the process, stick to the process, stick to the procedures. If it's recorded, shouldn't be within dispute, right? Unless you did something that you shouldn't have done or didn't follow procedure. So, follow procedure. This is week 11. Next week, we go on to a review of circumstantial evidence. The Scarlet C, something we've been discussing since week 1, when we introduced the fact that many cases are proven by a whole string of circumstantial evidence tied together, sometimes by direct evidence, but a whole bunch of circumstantial evidence presented by who? People, right? People, witnesses. But that's where we're heading next week. And again, I said week 12. That means we only have 4 more weeks after that. And it's closing quick. So keep your energy. Keep up the good work. Stay healthy. Lots of new COVID cases, so I hope you don't get it if you haven't had it. And, you need me. You know where to find me. Stay well.